Sometimes an Arizona court is asked to make changes in a child custody order that was issued in another state. In order to be sure that custody laws are applied consistently, most states, including Arizona, have adopted the Uniform Child Custody Jurisdiction and Enforcement Act that provides rules for interstate child custody cases. In the case of Melgar versus Campo, the Arizona Court of Appeals discussed the procedure an Arizona divorce court must follow when it is asked to change a North Carolina child custody order. Lillian Campo and Rafael Melgar, an unmarried couple, had a child together in North Carolina. The relationship fell apart and Lillian left the state with the child. Rafael went to family court in North Carolina to seek custody of the child. Lillian did not appear for the hearing, but sent a letter to the court alleging domestic violence. The court awarded Rafael custody of the child. Rafael located Lillian and their child in Arizona and filed suit there asking the court to enforce the order giving him custody. Because Lillian made allegations of child abuse, the Arizona court determined that it had authority to act on an emergency basis. It held a hearing and changed the custody order to give the mother sole legal custody. Rafael appealed. Now, one important aim of the Uniform Child Custody Act is to prevent states from issuing competing custody orders. To achieve this end, the Uniform Act says that the court making the initial child custody ruling has sole authority to change its order in the future unless it gives up that authority or both parents move out of that state. This is called continuing jurisdiction. Jurisdiction means that the court has a right to rule on a particular action between the parties. In the Melgar-Campo case, the North Carolina court made the initial child custody ruling. No evidence suggested that the North Carolina court gave up its jurisdiction, and although Lillian moved to Arizona, Rafael still lived in North Carolina. That meant that the North Carolina court had continuing jurisdiction. If one state court has jurisdiction of a child custody case under the terms of the Uniform Custody Act, another state may only exercise emergency jurisdiction. That means that the court of another state can only step in and modify the custody ruling if a child or a parent is in danger, and then only on a temporary basis. If a case involves emergency situations, courts are authorized to enter temporary custody orders to protect the children. Emergency jurisdiction and the company orders, however, are a temporary exception to the exclusive continuing jurisdiction of the state court that issued the initial child custody ruling. In the Melgar-Campo case, the Arizona court determined that Lillian or the child was at risk and entered an emergency order giving the mother sole custody. To that extent, it acted within its proper emergency powers. However, the court did not intend this as a temporary measure allowing Lillian to return back to North Carolina and ask that court for a modification of the custody order. Rather, the Arizona court went on to modify the original custody order to give permanent custody to Lillian. This was contrary to the terms of the Uniform Child Custody Jurisdiction and Enforcement Act, and in fact, set up the dueling custody orders the act was intended to prevent. The Court of Appeals reversed the trial court's decision and sent the matter back to the lower court for further proceedings.